How's it going, everybody? I'm back. I finally got a response from the Appellate Division. They got my 5 cases that you can hopefully see here. They unfortunately dismissed my 5 cases in the Appellate Division. They dismissed my appeals, which means I didn't win, I lost. Now, I'm happy, and at the same time I'm confused. Now, I'm happy because now I can move forward and do more things, of course, still against Glendale. But I'm confused because for some reason, and I'm going to explain this to you as to why I believe I lost, but for some reason, the Glendale branch of the LA Superior Court just lied and said that there was no recording of me. They never recorded me at trial or arraignment or any pretrial hearings, if you want to call them that, because it's an infraction case. So I don't understand why they would do that, knowing that when I say something, I usually have proof of it. Stupid is, stupid does. What can you do? But nonetheless, the Appellate Division came back and said, well, because what happened was, when you want to appeal, you can do what's called a settled statement on appeal. You can get a copy of the record, or you can even get a transcript, a verbatim transcript of the record, and you got to pay for that. Well, of course, I checked off I want a copy of the record, and I want to also get a verbatim transcript of the record, and I was willing to pay extra for both. But of course, they said there is no record, so the Appellate Division said, well, defendant is not entitled to a verbatim transcript of the proceedings in a traffic infraction case, citing Mayer v. Chicago, 1971, 404 U.S. Then they say, a settled statement has been found to be a sufficient substitute for a verbatim record or transcript, citing People v. Gordo, 1970, 8 Cal App 3rd, 275, 280 through 281. So I responded when they had said something similar to this. I responded with, well, in the California Constitution it clearly states all superior courts shall be courts of record. Did they touch that? No. I also claimed and alleged that Judge Green denied me access to the court and also denied me to cross-examine the witness. She told me I couldn't cross-examine the peace officer because I was not an attorney. Did they even touch that? No. I also claimed how Commissioner McTaggart was objecting to things that was irrelevant. For example, he wouldn't even let me question the officer. And of course, that could be just my opinion, and I could be wrong. But did they touch that? No. So, effectively, I claim that they have denied me the right to perfect my appeal. Because now there is no record, and just so you guys know, a settled statement on appeal is a joke, because what happens is you got to write down from memory everything that happened. Now, let me show you how crazy that is. In one of my cases, I cross-examined the officer for 40 minutes. Now, can you imagine writing a statement on appeal on a 40-minute case or cross-examination? It's impossible. You can't remember everything you asked the officer unless you write down specifically word for word beforehand. But even then, you can't or won't have enough time to write down what the officer responds with. So it's impossible. However, they didn't touch any of this stuff. Now, there's a saying that comes to mind. Fear the man who has nothing to lose, for he who has nothing to lose has nothing to fear. And because they have effectively done this to me by lying, one, and of course now dismissing my cases, I have nothing to lose because I've already lost. I've lost everything. All my 5 cases. I won 2, but that's not a win for me, because the cops just didn't show. And I even asked for a continuance, and I wanted to cross-examine them, but whatever. So my point is, now the videos will be coming forward. So it only has just begun, and my next step is to make a motion to vacate void judgment. So it's a win-win for me. Either way I win, because Now I can prove that what they were saying was not true, and they did lie, and they did say they were recording me, and now I can also prove other things. So this is a little taste of the Appellate Division, but then again, we do got to remember Appellate Divisions are in and are still part of the LA Superior Court. So it's not going to bite the hand that feeds it, because it's its other hand, basically. So keep that in mind. Hopefully you guys like this video, and I'm going to keep you guys posted as to what else I'm going to be doing with these cases. Thanks for watching.